So do I need to update my entire estate plan if I want to make a change to just one or two of those documents? That's what we're talking about today on Wills on Wednesday. So this is attorney Amy Rafecca. We're here on Wills on Wednesday, and I'm using a little bit different tech gear today, trying it out, just seeing how this works. A little bit of a different microphone, which is why I have these headphones on so that I can hear whether or not it's getting picked up or not. So that's why you might see me looking a little bit different today. So do I need to, so there's a few questions we're going to answer today. And the first is if I want to make a change to one document, do I need to change everything else in my estate plan? The next question we're going to answer today is, do I need an entirely new document if I want to make a change, or can I just do like an amendment or attach a change onto an existing document? And the third question I'm going to answer is, how often should I think about updating one or more of my documents in my estate plan? So that's what we're talking on Wills on Wednesday today. So the first question is if I want to make a change to one document, do I need to make changes to every one of the other documents? And honestly, the answer is maybe. And the reason I say that is because it depends on the change you want to make. It depends on the document you're making the change to, and it depends on how that particular one document interacts with the other documents in your estate plan. So what is an estate plan? And we've mentioned this in past episodes, and you're welcome to go to my YouTube channel at Atlanta Wills and Trust Law Group on YouTube, or look me up, Amy Rafecca, on YouTube and check out those videos. However, in short, an estate plan is several documents that work together that create a plan so you and your family have a plan of action in the event that you are ill, incapacitated, or when you pass away. And those documents include, at a minimum, a last will and testament, a financial power of attorney, a healthcare power of attorney, which includes your end of life decisions, sometimes referred to as a living will, a HIPAA document, which gives important people that you want to have access to health information if needed. And sometimes you might have an estate plan that includes a trust, and there are other documents associated with the trust. And sometimes you might have some additional pieces of legal documents in your estate plan that complement one of those other documents I just mentioned. But those are the main documents. And if you have minor children, and that is children under the age of 18 here in Georgia, you should also have a nomination of guardianship in the event of an emergency, or a temporary inability to care for your children, or permanently if you pass away and your children are under the age of 18. So those are the main documents. So if one of the changes that you want to make is in only one of those documents, do you need to make changes to the other documents? And again, the answer is maybe. If you want to, say, make a change in your last will and testament, and of course that's the document that goes into effect after you pass away, and then you're going to you will have selected one person to do all the work associated with what happens when you pass away. And what really needs to happen when you pass away is a few things. All of the things that you own in your name only, or potentially with another individual, will come together in one place. All of the debt that you have accumulated during your lifetime will come together in one place. And the person you have nominated to be either your executor or personal representative, it depends on the language used, but more or less the same person. The person is in charge for gathering these things up and making sure that your debts get paid, that they have all of the things, they hold on to them safely, and then your will instruct them who to give how much to and in what way. That is an executor. If you want to change the person who is named as your executor, that might not be a big enough of a change where you need to go and disrupt your entire estate plan and make changes to other documents. You will likely be able to just make a change to that document. And to answer the next question that we had talked about early on, do I have to get an entirely new will, or can I just add something onto my existing will? So I generally have a professional preference to not make add-ons to wills and to generally replace the document. But occasionally I will do an add-on onto a will. as long as it's really just the first one and it's a minor change. But generally speaking, it's a good practice to have to replace that document, because then there's no chance of that amendment or additional change being misplaced or separated out from its original will. So the amendment or the exhibit, or what we call in, estate planning world, the codicil, doesn't get separated away from the original will, which has happened in the past, and it can cause an issue and disruption in your planning process or in your administration. So you want to make a small change like that, probably don't need to change any of your other documents in your estate plan. However, if you want to make a change, for example, you now wish to be cremated, and this might be mentioned in more than one document. So that's what you have to be very mindful of when you make a change to your existing estate plan. You have to be very mindful of the fact that you could have also mentioned this same choice in another one of those documents. So that's why it's always a really great idea to have an attorney involved, because they should be aware where those other mentions are. And thank you so much for joining us, Hermie. I just really appreciate it. If you have any questions or anything to add to this conversation, I would love to hear about that. So that's the first question. Do I have to make changes to just the one document if I want to update my estate plan, or do I have to get all new updates to all the other documents? A really good example of when you might need to really impact other documents is when you are nominating a guardian for your minor children. You really strongly might need to consider getting the assistance of an estate planning attorney to help you with that, because there is a very good chance that that will impact your other documents in a significant way. And that is one of those really sacred choices that you make as a parent, and you don't want there to be any lack of clarity around who you want to choose in your estate plan to care for your minor children if you cannot, whether it's even in a temporary way, but most assuredly a permanent guardianship decision. So that's the first question. Do I have to make changes to other documents if I want to just make one? And the simple, short answer sounds really lawyerly. Maybe you might have to make other changes. It depends on what the change is and how significant. The next question we're going to answer today about updating your estate plan is, do I have to replace the whole document, or can I just add on to that document? And again, I already made my professional preference known. It is a really good idea, professionally speaking, my opinion, replace the document. That way there's not the potential that your change in your original document somehow become detached and then there's a potential for lack of clarity again around your choice. You have invested your time, you have invested your money, and most especially you have invested your emotional energy into getting your estate plan in order. And you really do not want to create a situation and set up your estate plan to have any lack of clarity around it in the future for your family. So sometimes when you make amendments to a document and you have two separate pieces of paper that reflects your wishes, sometimes there can be some lack of clarity. I will say one of the areas or one of the documents where I see the most amendments without a full replacement is a trust document. And trusts are sort of a special beast when it comes to estate planning. And so you're more likely to not replace the whole trust document, but you are more likely to have an amendment on a trust. One of the things that we do at Atlanta Wills and Trust Law Group to ensure that those additional amendments onto a trust don't become detached and separated away from the original document is we actually bind our trusts together. So we actually have it spiral bound, and we will take the original, we will take any amendments, and we will put all of those together, the signed amendments, the original signed amendments, and the original signed trust, and we will bind them. And if you ever make a change in the future, it is not difficult to unbind and rebind, but we do that so that way there are no separations away from the original document. And there's no lack of clarity around your choices again. So that is one area where we do occasionally, instead of fully replacing a document, we will append or add onto a document any changes. But again, in my professional opinion, it's a good idea to replace documents rather than amend documents generally in an estate plan. And the third question is when is it a good idea for you to look at your estate plan and update? And again, we have a separate video on our YouTube channel at Atlanta Wills and Trust Law Group where we discuss something called the 6 Ds, which is what we recommend to our clients when we are sending them on their way with their completed estate plan. And these 6 Ds talk about times in your life where you want to think about your planning and whether it makes sense to you. So that video will go through those 6 Ds in more detail. But here is what I generally will recommend to anyone, no matter what state you live in really, and no matter what your life situation is that whenever a major life event occurs, so shifting of money, change of people, change of locations occur in your life, you should at least think about updating your estate plan. That's always a good idea. Another good idea when it comes to updating your estate plan is stay in relationship with your estate planning attorney. It always boggles my mind that I will hear about someone saying it was just a transaction and I haven't spoken to my estate planning attorney in 10 or 15 years, or I haven't seen or heard from them. I don't even know if they're alive, and their estate planning documents may be 20 or 30 years old. I'm not faulting anyone in that situation. However, I am here to say stay in relationship with your estate planning attorney because the laws can change, things change. And while, it's very rare that a law change will completely invalidate something in your estate plan, there are updates to the law for a reason because they're generally going to benefit you in this type of situation. Here in the state of Georgia, in 2016, we had a really significant update to our healthcare power of attorney law. In 2017, and then again in 2018, we had a really significant and beneficial update to our financial power of attorney law. Stay in relationship with your estate planning attorney, and you will be more likely than not be able to take advantage of those updates in the law if you want to. It's really sort of a knowledge is power situation. So I recommend staying in relationship with your attorney. We do like to reach out to our attorneys or our clients, and see how they're doing. Sometimes we provide them additional information, maybe not so much on law changes, but just on things that could help their family or them in their estate planning. And we just like to see what's going on in their lives. And so I recommend, you don't have to be best friends with your estate planning attorney. I'm not recommending that, although I do have good friends who are, my clients. But what I am trying to say is it is a good idea to at least know where they are, know who they are, see if they're still around, especially if you live in a state or you happen to have left your original will or original trust with that attorney. That is imperative that you stay in contact with that estate planning law firm. So a little bit longer today, Wills on Wednesday. If you have anything to add to this or you have any specific questions, you are welcome to reach out here on Atlanta Wills and Trust Law Group and ask us that. You can reach out to us by dropping a comment. You can reach out to us at emailing us at team, T-E-A-M, @refecalaw.com. That is R-E-F as in Frank, E-C-A-L-A-W.com. Or you can call us at the office and schedule a free consultation, 770-508-6525. I am here in the Metro Atlanta community, so that might impact your decision about whether you can come and see me or not. However, reach out to us. We can usually connect you with someone in your area, even if that's out of state. We have a lot of contacts in and around the U.S. And actually occasionally even internationally. But I hope you have enjoyed this episode of Wills on Wednesdays, and we're answering the question, do I need to update my entire estate plan or just the one document if I want to make a change? Thanks for joining me. I really appreciate it. Wills on Wednesday, Atlanta Wills and Trust Law Group signing off.